of people, we can see the numbers ticking up. So we're just going to give people a couple minutes to get logged in and then we'll get started. What do you think? Should we get going?
Yes.
All right. Well, good afternoon, everyone. Welcome to our webinar today, which is the employment law update, delving into the 2024 legislative changes to the Minnesota employment laws. Some of you were with us in February, where some of the employment people, including me and my partner, Amy Dayhoff, who was supposed to join us today as well, but is unfortunately sick, previewed some of the things that were going on with the session. And I have with me today Tom Hansen. It's fortunate in our firm that we have a robust legislative group, and so I can partner with Tom and have my finger on the pulse of what's going to happen and what actually does happen. And so for today, we're going to focus on what did happen in this session. Again, my name is Laura Pfeiffer. I've been with the firm for 29 years, and I co-chair our employment group, and I'll let Tom introduce himself.
And I'm Tom Hansen. I chair our legislative group, and I have been at Winthrop for 14 years. And prior to that, served as the state's Minnesota Management and Budget Commissioner and various other government jobs.
All right, so I'll let Tom go through. So there was, like, as we had forecast, a lot of things were being discussed and a lot of things actually did happen. And that's what we're going to focus on today is what were the changes that actually passed.
Thanks, Laura. And it unfortunately seems like an annual rite of passage that we talked to you in July about all of the changes that you have to get ready for as a result of the legislative session. If you've joined us before, we've talked about the fact that the Democratic Party in the 2022 elections took control of the state House and Senate, and Governor Walz, being a Democrat and in the middle of his terms, they have a trifecta in all of the governing institutions in our state. So that has led over the last 2 years to a number of pro-labor and employee right advocates pushing various legislation that they have been wanting to do for decades. And now they have the chance to do it. And what you see before you on the slide is what we are going to talk about today. In the middle, you see the earned sick and safe time and paid family and medical leave. They passed last year. There are some modifications to that this year. Then there's kind of a cluster above that of what I consider employee rights advocates have been pushing not only here in Minnesota, but elsewhere around the country. And then below that, we have some other issues as well that we'll get to. And what we're going to do is I'll generally talk about what the legislature did, and Laura will jump in on that when she sees something I may have left out or she wants to expound on. And then she's going to give key takeaways that, kind of are hands-on kernels for you to walk away with that you need to do.
Yeah, some of these things are small things that we just want to make you aware of. Other things are a bit larger, or other things you may want to incorporate. Because we know a lot of people were exhausted after last year. Like, leave us alone until paid family leave in 26, right? So,
that's right.
But nevertheless, there are some things for you to take into account, and we want to make sure that you're prepared, and we're here to help. So. All right, so kicking us off here, there is a small change to drug testing. And so as I understand, and I'll let Tom summarize, this doesn't change anything about kind of or expand what you can test for or when you can test. It just provides an additional option of how to test, right?
That's right. It's designed to hopefully make your life easier. Not a lot of these provisions we're going to talk about today are like
Fall in that category.
Fall in that category. But the legislature did do change, there were a number of changes to drug testing last year. And the fact that Minnesota legalized cannabis last year resulted in the 2023 legislature making changes to the drug and alcohol testing in the workplace. So the specific provision we're talking about becomes effective on August 1st, 2024, and on a few weeks. And it allows employers to use oral fluid testing to test employees and job applicants for drug, alcohol, and cannabis use. And the benefit of this, it provides accurate and rapid testing results by potentially eliminating the need to use the slow and costly testing at a testing laboratory. That was becoming a problem for some people.
Yeah, I mean, it was my understanding that some of this came up because employers were concerned they were losing candidates, like because the drug testing process was too slow, right? And so, or sometimes there's transportation issues with employees, so they can't get to the lab in a timely way, or that was kind of a backlog of things. And so really, this was just allowing a saliva test, right? Which you could do on the spot and be administered by people to alleviate some of those issues. So I know when I first looked at it, I was concerned, like, okay, what does this mean? Like, what are employers going to have to take on? Is this going to be challenging or be rife with problems? But then I think when we were talking about it, we talked about, well, like people have been doing this with COVID tests, where they were administering them on site sometimes. And so people kind of got used to it in a different way. And so I've come around and understand a lot of states actually do this. And I feel like this could be a really great option for people, provided they use one that's approved and, otherwise is supported and, provides reliable results.
Yeah, and it's a good example, Laura, of where the legislature actually balanced well the needs of the business and the needs of employees. You'll look at the current slide. You're responsible, you have some new responsibilities. You must immediately inform the employee or applicant of their test results. And then in the event of a positive, inconclusive, or invalid test result, the employee or applicant may, within 48 hours, request an employee use an approved testing laboratory at the employer's expense.
Yeah, one thing I read on this for people in other states that have used this is that the vast majority of the tests come back negative. So, it's not that it's always going to result in people having to go to the laboratory. So then like you're basically adding a step or other expenses, right? So if I mean, I think for a certain class of employers that this could be a really helpful thing to add to kind of how they go about drug testing. All right, so the key takeaways, as Tom had mentioned at the outset, that's part of what I'm going to be speaking about today is sort of what to do with some of these changes. So one thing is, there were a lot of changes with cannabis being lawful in Minnesota last year. So like if for you are doing drug testing and you have not updated your policies already, make sure that you have done that. Again, like that should have been done last year, but sometimes that gets lost in the shuffle. And so, there are changes that need to be made if you are drug testing based on the 2023. Consider whether this new ability to use saliva tests would be helpful to you. Again, it can be cheaper and quicker, like you can possibly not lose candidates due to the timing of those test results. Again, you may have a con, you may need to go to the lab anyway, but you're assuming that the vast majority of them are going to come back negative, such that you wouldn't have to do that. And then if you are doing that, you just need to make sure that you're following the rules and you're informing people immediately. And then if they request it, allowing them to go to a lab if it is positive. All right, so the next topic of change is job postings and needing to add information about salary ranges.
This is part of a trend, not only in Minnesota, but in other states, to try to provide more transparency in the hiring process. If you recall, last year, the legislature passed the pay history ban, where you were restricted from asking an individual what their current pay was. This year, the legislature, and effective January 1st of this coming year, 2025, employers with more than 30 employees must provide a good faith estimate of the salary range for any job posting. And these postings must provide a salary range with both ends, a minimum and a maximum salary range or expected hourly rate, and include a general description of all benefits and other compensation the applicant can receive. And if the employer does not wish to provide a salary range, it can provide a fixed rate.
All right, so for one of the things I wanted to mention is that this pay transparency law, they already have similar laws in California, Colorado, Illinois, New York, and Washington State. And so I wanted to, one of the key takeaways is that you need to consider, like, if you have greater postings, or if you're posting nationwide, whether one of those other states already might have some other restrictions. So next is that one thing to consider is now, since you have to start doing this in January, are there any employee relations impacts? So if existing employees don't know what people are earning, now, again, Tom mentioned you can't prevent people from discussing that now, so they may be discussing it anyway. But in the event that they don't, this may be the first time that people might know kind of the salary ranges for either their position or a similar position. So just to keep that in mind and possibly head off any employee relations issues, or maybe you need to have broader conversations with some of your employees if you think that's going to be a concern. Obviously, start thinking about how you want to determine those salary ranges so that you're ready in 25. You'll need to also add the general descriptions of benefits and other compensation that have to be in that job posting. And then determine, you can have just a fixed rate if you so chose, which is like the exact salary or hourly pay that the employer intends to pay a successful applicant. So that could be an option instead of the range if you want. And so, for people that are involved in these tasks in your business, you'll want to train them to make sure that they understand what to do about that. And also it applies to any third party that you use, such as a recruiter. So you'd want to make sure that you're communicating with them about how to be in compliance, because just because someone else is working with you on it doesn't mean that you're absolved from the responsibility for this. The enforcement of it is going to be the Minnesota Attorney General and Minnesota DOLI. There isn't specific penalties for noncompliance that are stated now, but of course we are encouraging people to make sure that they are starting to look at this so that they are ready for when they do need to do postings in January of 25. One question that was asked is, will the slides be available afterwards? I know that the slides will, I believe a recording may be as well. So, but we will send a follow-up email after the webinar and let you know kind of how that's going to be handled. All right, so it looks like there was one other question, Tom. I don't know if you had a chance to read that when I was speaking, but
when we post, do you think we would do a starting pay range or list the full salary range of that role?
Yeah, I mean, I think it just needs to include like what the minimum and maximum could possibly be for that role, right? Unless you wanted to do the fixed rate. And so is that responsive to that question, or right? I'm not sure I'm fully understanding that.
Well, I think the question is.
Oh, right.
if
So
the
like
ra-
what,
yeah,
if it's
if
like a
the range
starting
is-
person versus
like-
like someone that was more experienced.
Yeah, so you have, I don't know, 50,000 and the
Gotcha.
upper
Yeah.
range is 80, but to the person, you know, the starting pay is, you know, based on your experience, you can be 50 to 55. I got the sense it's the full.
Yeah, I mean, I think, again, like all of this is brand new, so we're, trying to determine it, but if you were possibly considering hiring for someone from that role that had a range of experience, right? What such that the two, like a starting person and someone more full would be considered, I think you would consider all of it. If you really were looking for only entry level, then I think it could be a narrower one, so. uh, Great. All right. Thank you for responding. We were just wanting to make sure it's sometimes hard to read the chat at the same time that we're speaking. So thank you for being patient with us. Okay, so next, restrictive covenants and service contract. So I think this was an attempt to fix a possible loophole from the legislation last year on non-competes. But I'll let Tom explain what he thinks.
Yeah, thanks, Laura. And yes, it is a fix from last year, and you'll notice a lot of the law changes are clarifications, modifications, or just plain fixes from the 2023 session. In this case, effective 3 or so weeks ago, July 1st, Minnesota law bans service providers from restricting customers from soliciting or hiring their employees. In other words, when a business provides services to a customer, the businesses cannot prevent its customers from directly or indirectly soliciting or hiring its service employees. This prohibition does not apply to consultants who consult for computer software development and related services through a service provider. Businesses providing this service can still utilize restrictive covenants.
All right, so in terms of the key takeaways for employers here, this is going to really affect a narrow group of individuals, right? Because you have to already be in this business where you have a service contract in the first place. And so if you are in that category, you need to look and confirm that your business doesn't have anything that's going to violate. And if there are any, you do need to send notice to those individuals that restricted covenant is void and not enforceable. If there are any existing contracts that you are going to use in the future, you'll need to remove that. But then, to keep in mind that there is this exception. And so in the exception, I did want to speak a little bit more about that as to kind of how that is defined. So and I have the actual language here. So it says that it does not apply to workers providing professional business consulting for computer software development and related services who are seeking employment through a service provider with the knowledge and intention of being considered for a permanent position of employment with the customer as their employer at a later date. So the legislation does take into account that exception. And so again, this is a very important issue for some businesses because this is on all fours with the types of things that they do. So if you have further questions about that, feel free to reach out. The one thing that when I was reading more about this is that what is not addressed is sometimes in these types of contracts, there's a practice of imposing a conversion fee on client companies that hire workers. And so meaning that like you can hire our person, but you have to pay for it, right? So it's not restricting it per se, but it is allowing for sort of a different structure if that's going to happen. And so that is not explicitly banned by this legislation. And so again, all of these things are brand new and we're, trying to absorb like how they would be interpreted. But, that type of practice, which is designed to recoup kind of onboarding or training expenses, if somebody picks off your person in a way that you weren't wanting, or at least you wanted to be compensated for, is something to consider as a possible option. Okay, so next, access to personnel file. I think in some respects, this was a little surprising to people because like the fact that maybe this didn't apply to everybody wasn't exactly known before, but.
Oh, exactly.
But anyway, tell us a little more about that, Tom.
Yeah, it actually was introduced as a standalone bill and rolled into a larger, amended into a larger bill. But now all private employers are required to provide access to employees' personnel files if the request was made in good faith. And I think a lot of us think, well, yeah, but I think and I should have looked it up again before I came here, but I think it was employers under 20 this didn't apply to.
Right, I think that is right.
Yeah, so you'd have to be a pretty small employer to have this impact you.
Well, and I think just practically speaking, most employers, especially for existing employees, are not intending to hide the ball with their employees as to things that are in their files, such as performance reviews or other things, right? You know, and so it's not really surprising that this was fixed. And again, I think like a lot of employers expected that it applied to them in any event. But again, key takeaways, you know, all employers, regardless of size, have to provide employees with an opportunity to review their personnel record as defined by the statute. So, and when there is a request like this, I really encourage employers to carefully follow the process. So if a request comes in, a lot of times if there's questions, like, because what an employer might keep as a personnel record may not actually line up with how it's defined under the statute, because personnel record is clearly defined. It says this is what it means and this is what it doesn't mean. And it's in these 181.960 through 66 statutes. And so, and there is a time frame for how you have to go about providing it. It differs based on whether it's in the state or not. But just to be mindful of producing what is required and what's not required. It doesn't matter whether the employee sends a release saying, I want more than that, right? Because what we recommend is that people only, you know, this is short of litigation where there would be discovery obligations. But so that if somebody sends something, be mindful of what to produce, have it follow how personal record is defined under the statute. I usually have them include a letter that says, you know, pursuant to Minnesota statute, whatever, enclosed please find your personnel record as defined by the Minnesota statute. Very truly yours, you know, that's it, right? And so then if there's a question later, that the employer's response is that they followed the statutes and produced what was required, and that was it, right? So nothing more, nothing less. And if there's ever questions about that, we often get sent like, here's what we have, tell us what to produce, and then we kind of help with that if an employer has questions. Okay, so next, sick and safe time. So a lot of our clients were exhausted about how to manage sick and safe time from last year and spent a lot of time and effort trying to get in compliance and figuring that out. And so, but there's other changes, right?
We have some other changes.
Yeah, what are they?
Our next cluster of slides, first it's sick and safe time, followed by the paid family leave. Our major legislation that passed last year that now the decision makers came back to make modifications. So modifications, things they felt they need to change or add or that sort of thing. So the slide but that you're looking at now, a lot of words, but essentially the gist of it is the legislature wanted to give employees a remedy if employers aren't doing what they're supposed to do under the sick and safe time. And that's so employers who do not sufficiently provide or allow use of sick and safe time to employees are liable to employees for the time the employees should have been provided plus an equal amount of liquidated damages. And then if employers fail to keep sufficient records, the employer is liable for 48 hours of sick and safe time and an equal amount in liquidated damages. So just a way the decision makers wanted to be able to hold people accountable.
Right, just put a little more teeth into like, what if you don't do anything, right? You know, or you just don't add this or address it, right? So it's like, okay, well, you're gonna get the full amount and double it. And so just really encouraging people to get in compliance if they aren't already.
And now the first point on the slide, I have a feeling that we may, Laura, be seeing year after year pressure to add more things under the definition of what you can take sick and safe time for. In this case, they added making funeral arrangements and addressing financial or legal matters stemming from a family member's death. So 2 more items to the definition of what you can take sick and safe time for. And it's something that I think the business community collectively is going to have to track over time, that this doesn't get, you know, a little out of hand.
Mhm.
The next thing, employers no longer need to specify sick and safe time on pay statements, and they can instead use their own reasonable system to provide employees this information. Employers must keep earned sick and safe time records for 3 years. And then the law changes. Employers can now track how much sick and safe time employees use in increments between 15 minutes and 4 hours.
Yeah, I think in this last one, that this was an attempt to deal with the fact that a lot of employers track increments in less than a minute. Just because of the payroll systems that they use. And so, you know, it was originally the smallest increment of time tracked by the employer's system, which just was very burdensome because if you had one that tracked it to a very small increment, then you could be forced to allow people to take sick and safe time in that increment. So now it's at least between 15 minutes and 4 hours. And so I think that was what that was intended to address. So some key takeaways for employers, you know, given the harsher penalties, employers really need to ensure total compliance with sick and safe time. Now, again, like we were encouraging everyone to get in compliance in any event, but I think some of those new penalties make that even more, underscore that, that advice. Allow workers to use sick and safe time for bereavement-related issues. And I think that even though a lot of you were very diligent and worked with us and other legal counsel to get your earned sick and safe time policies up to date, some of these changes really do necessitate some changes to the policies that are in your handbook. So for example, like I had one of the members of my team send me the red line that we had done for someone for a policy that we had worked on. And, you know, so adding the ability to make arrangements for attend funeral services or memorial, the change that Tom had mentioned is redlined in here. The same issue with allowing you to take time in increments not less than 15 minutes nor more than 4 hours, also in here because your original policy may not have said that because that's not what the law was, right? So I do think that it makes sense to make sure that you're aware of these changes. And then if your policy is not up to date in light of those changes, making sure that you're doing that. Next, I think a lot of companies were having trouble putting the sick and safe time on the earnings statements. They were working with their payroll providers in order to do so, but really you wanted to kind of have a live ability to determine what you had and how much had been used for sick and safe time based on whether you were front loading or accruing overtime or how you were managing that. And so, so my advice on this piece is if you already have sorted that and have it on your earnings statements, it may make sense to just continue with that because you then know that is available. If you do use another system because that just wasn't working for you or wasn't practical, it can be an electronic system, this reasonable system to communicate, but you then need to have an employer-owned computer where employees are able to review that information and print the statement. And so sometimes that could also be challenging to sort, right? You know, and so again, like be aware that there is an option to use a different system, but make sure that you're in compliance with what that system is. And if you already were able to get it on your earnings statement, that may just be the simplest way to continue with that.
So Laura, we have a question. Is there a wage threshold for sick and save time? If we have someone getting paid $80 an hour, would they qualify?
I don't think there is a wage threshold with that, right? Although the question actually raises one point I did want to add to this is that they changed the rate of pay for earn sick and save time as an additional change. And so the amendment substituted base rate for hourly rate. And so, for example, if you had people that were paid multiple rates, the base rate would be the amount that would have been paid for the time the person was, you know, when leave was taken. And so, and then it also has said that if there are additional changes, for example, like if people were on commissions or piecework, you know, how to manage that. And the prior act was silent on that. And the amendments clarify that the base rate does not include commissions, shift differentials, other things, but employees that receive earn sick and save time have to earn it at a rate no less than the minimum wage. So, so that's just something to be aware of, is that there were some additional changes on that as to how to go about paying the earn sick and save time. But at the same time, there are rules about, you know, I mean, I think like anybody that works 80 hours within the state is eligible for earned sick and save time.
And then we have one more question. Is there a time limit for employees claiming sick time? For example, they were gone last week versus gone 3 months ago and wanting to claim.
With the earn sick and save time, people are allowed to use it as soon as it's available. So it, you know, if you've chosen to front load versus accrue the time. So I think the short answer is no, but you need to allow them to take it as soon as they are eligible. And then, you know, depending on the manner in which you've decided to provide it, whether it was front loading or whether you were accruing it over time.
Okay.
Okay, so next we've got paid family and medical leave. So this is one where we have told people when we have spoken on this before is that this does not go into effect until January of 26. But at the same time, we want people to be aware of what some of these adjustments are, like how this is developing. And also there are some things that do need to happen this year, and just kind of really suggesting people be proactive about planning for this so that they don't get to January of 26 and then, you know, not know what to do, since there's a lot to consider and appreciate.
Definitely. And early this year, there weren't going to be the proponents of paid family medical leave and the Walz administration had not anticipated making any changes. But we do have some, and in particular, the later last year, they had an actuarial study that determined that based on the premiums that they had put into the law, that they didn't have enough, they probably weren't going to accumulate enough money to implement the program. So effective on January 1st of 2026, the payroll tax will increase from 0.77% to 0.88%. And then because over the interim, they were barraged with small business employers and people with fewer employees, employers of 30 or less whose average wage is not more than 1.5 times the state average wage can have premiums that are 25% lower. And these reduced premiums are divided into employer-employee portions where the employer must pay at least 25% without deducting pay, and employee pays the rest through wage deductions, designed to make it a little easier.
Okay, so for the key takeaways for employers, so one thing I did want to alert people to is that we just put out a comprehensive paid family and medical leave e-alert, so which is on our website. And so that has a lot more information about paid family leave. This was just really the tip of the iceberg on some of the types of things that this new law is going to entail. And so I really want to encourage people to do that to help them plan for the 2026 implementation. Some of these changes that Thomas mentioned are somewhat technical, are allowing for the fact that there is going to be, it was more expensive than was originally anticipated, right? And so
Yeah.
just kind of how that was going to end up affecting employers. For the kind of other to-dos and takeaways, some of you may know this, and I have been encouraging everyone to sign up for the updates from Dolly. So if you go onto the websites, you can sign up for paid family leave e-alerts. And so you'll get an email with kind of new information. And so I think at first it was not working very well. I think I'm signed up both with Deed and with Dolly for any updates. And so I would encourage people to do that. But one thing that is going to happen in 2024, and this is also in this e-alert that is on our system, is that employer wage detail reporting is going to begin in 2024 with the first report being due on October 31. And they're using the same unemployment system accounts to report this, which is intended to make things easier for everyone. But just be aware that that is a requirement for this year. The other thing that we've encouraged people to start thinking about and gathering information is whether it might make sense to use a private program as opposed to being part of the state program. And so that is, I don't know that any private companies have been approved so far, but they're actively in the process of working towards getting approved. A lot of employers that I've talked to are looking at the companies that may be providing their short-term or long-term disability that may make things centralized in a way that would be helpful, but it's all going to come down to, you know, what the expense of that is going to be and whether that's going to make sense for an individual employer. But starting to gather information about that is another thing that we've been talking to people about. And then, of course, closer in time to when this actually happens, and people have an understanding of how they're going to manage that, they'll need to add policies relating to taking paid family leave to their handbooks and other things. So, but, you know, just starting to be mindful of planning for all of those types of things. Okay, so next we have independent contractor misclassification. So I can tell you that independent contractors being challenged has been a lot of work for my group lately. So we have been seeing challenges come in through the Department of Revenue. Just this week, I had another company where an independent contractor claimed unemployment. And so the issue was being reviewed through the unemployment system as to whether the person was properly classified as an independent contractor, such that if they were an employee, then they would be entitled to unemployment. So it's just getting a lot of airtime, and a lot of people are carefully looking at whether they have their people appropriately classified, which seems to make even more sense given this new change.
Definitely. This was a labor initiative in the last legislative session. And the whole idea behind it was they didn't want the businesses or certain businesses to get around all of this legislation they were passing by claiming that employees were independent contractors. So you can see the 3 points. As of July 1st, officers and agents can be held personally liable if they misclassify independent contractors. So there's a considerable incentive to pay attention to this. And then there's in addition to compensatory damages to workers, employers could be responsible for employees of up to $10,000 for each violation and $1,000 for each obstruction. And then most important, the definition of independent contractor in the construction field has changed. And employers in the construction industry should ensure they comply with worker classifications, and they're located on the Dolly website, and it's a multiple part test that you walk through to determine the classifications.
Right. So as the key takeaways here, now more than ever, you should carefully consider whether workers should be independent contractors. I'd say when people come to us and say, well, this person's going to be a contractor and they want that, or they agree to it and we have a contract, that's not going to be enough in any respect. So there's different factors that would be evaluated with the IRS, with the Department of Revenue, with the Department of Labor. And so really looking carefully at that so that you feel comfortable that you can support the classification is really important. It can have tax implications. It could have, these types of penalties with significant implications. There could be unpaid overtime implications. And so I think really the standard should be that people are an employee unless you can prove otherwise. And then if there are factors that are in your favor, right? Because usually not every factor is going to line up that supports the independent contractor classification. But if you have a form contract, for example, and there's additional things that are in your favor, it makes sense to add that information to the contract itself so that you have contemporaneous documentation to support the things that were happening. So for example, like if people have to use their own equipment, or they are able to work for others, or they advertise their services to others, or you're relying on their expertise, like all of those types of things you can add to your contract because it supports the classification and then is contemporaneous evidence at the time of these types of factors, right? Instead of like trying to argue it after the fact when you're in an audit or otherwise trying to support it. So, and then be aware of the new requirements if you are in the construction field as well. Okay, so next turning to pregnancy accommodations.
So these were amended last year being 23. They were amended slightly again this year. One of the new amendments requires employers to maintain insurance coverage for employees and their dependents when employees are on leave or for an accommodation related to pregnancy, childbirth, or related health conditions. And then employers are now required to continue an employee's group insurance policy, group subscriber contract, or healthcare plan as long as the employee pays their share of the cost of the benefits.
Yeah, so I think a lot of employers likely already do this, but just to make sure in the event that that wasn't the practice before, to ensure that that insurance coverage is being maintained during that pregnancy leave, and you can have the employee pay their share. So I think for most of our clients, this is likely kind of the practice they already have, but again, wanting to make sure to alert people of any changes to make sure everyone is in compliance. Okay, so there is a new poster.
I always wonder if the printing industry is involved in these new posters. The Minnesota Legislature instructed the Department of Labor and Industry to make an employee's rights educational poster in English and the 5 most common languages spoken in Minnesota. When this poster is completed, you're required to, employers must place the notice where employee notices are customarily located within the workplace. There was one last year too related to veterans' rights. They seem to have one of these every year.
So this one's pretty easy, monitor the updates to understand when that poster is available. And then once it is available, prominently displayed to ensure that you're in compliance. So whenever there is an audit by one of these industries, they'll come and look for the poster. So it may not be that you're getting an audit just to find out what the poster is, but if you have an audit on a wage and hour issue, for example, then they will come and look for that. And then that'll be an additional item that they will fine you for if that's not there. So it's an easy one to get in compliance on. You just need to make sure you know about it and then follow it once it's available. Okay, so there were a couple of changes to the Minnesota Human Rights Act this year. So Tom, can you walk us through what those
So
are?
there were several terms that have been expanded. Disability now includes an impairment that is episodic or in remission and would materially limit a major life activity when active. Discriminate now includes all harassment, not just sexual. And then familial status now includes those residing with or caring for incapacitated individuals. And then there was language regarding religious organizations, which was clarified.
Okay. A couple of other changes on the enforcement side.
Mediation or ADR is allowed. Party can contest a commissioner determination requesting to appear at a hearing on their own behalf or with an attorney. The commissioner must make a determination of probable cause or lack thereof within 1 year. It was previously 180 days, and then a party can bring civil action within 90 days, previously 45 days of receiving notice that commissioner dismissed the charge.
Okay, a couple of new penalties and relief as well.
Well, penalties and relief, violators must pay a civil penalty determined according to the seriousness and intent of the violation, the violator's financial status, and public harm caused. And then for for unfair discriminatory practices, courts must order compensatory damages, which can also include adjunctive relief.
All right, so for key takeaways for employers on this, first thing is just to look at your policies and see if you need to make any adjustment to your handbook language in light of some of these changes. On the ADR piece, that one was a little, I think the part of what I understand was the change was that it's now being offered to both sides. I'm almost 100% on the employer side, and the decision to participate in mediation or not has already been part of the process. And so what I'm often talking to employers about with a charge of discrimination is if there is some concern about the facts or the law on a particular charge, maybe it makes sense to mediate it. If not, I'd say that because you're not going to go to a mediation and have them dismiss it. You're not going to mediate a charge of discrimination and end up paying zero, right? So if there is a strong defense on the facts, the law, or both, it usually just makes sense to put in a statement of position and explain your position with the hope being that there will be a no probable cause finding. So I think on the one hand, there was a minor adjustment to this, but I think our recommendations on how to consider using ADR or mediation with the Department of Human Rights is basically the same. And then, if applicable, understand kind of some of the changes on the religious and political organization changes. Okay, so in advance of our webinar, when everyone signed up, there was some questions that were raised about what's going on with the FTC and the non-compete ban. And so even though that's not something that Tom was working on, we decided to add it to this webinar just so that people, because there was a few questions asked about it. So again, not to keep directing you to our website, but we do have some pretty helpful summaries of the, there's two. So one is FTC issues final rule banning non-competes, which is a pretty comprehensive discussion of what the rule is now, and so that you understand kind of what's potentially being banned, which is essentially all non-competes unless somebody is a senior executive, which is a very narrow exception intended to be really C-suite people, and like what that looks like and how that's defined is all summarized in this summary that we have. The other pieces that we have an update on that's also on our website that is talking about some of the litigation that has been, so there's multiple lawsuits that have been filed in an effort to not have the FTC rule go forth. So right now, there is the due date is September 4. And there is not clarity right now on whether the rule will be stayed. So there was a litigation, there was a decision that came out this week that we thought may be a nationwide injunction, and it was not. So the next thing on this is that there is a court in Texas that said that they will rule on the merits by August 30, which is not a lot of time between September 4, the due date for that. And one of the reasons that people need to be mindful of that September 4 date is because the rule requires employers to send notices to the people that have these restrictive covenants that they are no longer enforceable. So the FTC does have model language on its website that people could use as something to send out to those folks. We are not encouraging people to send anything out until it's clear that this rule is actually moving forward on September 4. The other thing is, while the FTC sample language is helpful, we have been working with our clients to be maybe a little bit more tailored to the specific agreement at issue and making sure that it's very clear, like what provision isn't enforceable, because unless it is a de facto non-compete, non-solicitation provisions are still enforceable, right? So you don't want to send something out that unwittingly gives somebody more of an idea that something might not be enforceable. And you certainly don't want to send something out now, like if you were to send everything out this week, for example, and then have to try to unwind that if the rule is enjoined or, you know, it doesn't go in effect as it is right now. And so so we are carefully monitoring the litigation on this issue so that we can help advise clients what to do. The other pieces that I have found, especially since Minnesota doesn't have non-competes any longer, there are employers that I think are maybe taking positions on hiring people with non-competes in a different way than they would have in the past. You know, being more aggressive is probably not the appropriate way to discuss that, but maybe just looking a little more carefully on if there is an overbroad non-compete that someone has and they want to bring someone on in light of the fact that they're not valid in Minnesota anymore, in light of the fact that FTC is suggesting that they should be banned, and if maybe there isn't a strong argument that the person that it's supported by a legitimate business interest, or, you know, the person isn't customer facing or other things, just maybe taking different approaches to hiring in light of the climate that we're in. So it's an interesting time, and we are very carefully looking at things. So again, like right now, we are assuming that the ban will be enacted. We're encouraging people to create lists of who they would need to send these notices to maybe start thinking about how to draft that notice, because, you know, September 4 is going to be here before you know it. Like, how would you like that to look? And be tailored to your specific agreement. Again, we're happy to help with that if anyone needs help. And then we will be sending out additional e-alerts and are carefully looking at all this litigation to see what that's going to mean for our clients and employers. All right, so I think we're at the end of our time. All right, well, any other final words, Tom, or?
You have our contact information in front of you, but we also will make the slides available. And if you have any questions, let us know. We'd be more than happy to help.
All right, thanks so much for joining us. We appreciate it. Have a great day. New post.